Green cards are getting harder, but two safe options remain. Getting a green card in the United States has always been complicated, but since President Trump's return to office, it has become significantly harder than before. Applications that once moved forward without major obstacles are now being denied outright. Many are delayed for months, while others are redirected to courtrooms for further scrutiny and challenges. For immigrants depending on these pathways, the shock has been devastating. What once felt like a secure route to safety and stability now feels fragile and uncertain. But here is the critical point. Even in this environment, two green card options remain untouched by Trump's policies. These pathways are safe, stable, and still effective today. The new green card reality. Family-based immigration, once the most common route, is now facing heavy restrictions. USCIS officers have been ordered to investigate cases more aggressively than in previous years. Marriage petitions are no longer straightforward. Couples with age differences, residency gaps, or inconsistent documentation are flagged for deeper investigations and often face tougher interviews than before. Asylum seekers are facing even harsher obstacles. The process was always long, but today it has become even more uncertain, with higher filing fees and growing risks of detention. Thousands of pending asylum cases have been canceled, and many who believed they were safe suddenly find themselves without legal protection and at risk of removal. The U visa, once a strong protection for victims of crime, is collapsing under backlog. More than 300,000 applications are pending, and wait times stretch to 15 or even 20 years. Employment-based visas like EB-1A for extraordinary ability or EB-5 for investors remain possible, but for most immigrants they are completely out of reach due to cost or strict requirements. This reality has left many with fewer options. Yet two powerful legal pathways remain available and untouched by Trump's changes. Safe green card pathway number 1, the T visa. The first pathway is the T visa. It was created by Congress to protect people forced into labor or services through threats, coercion, or control. Many assume it only applies to extreme trafficking cases. That is not true. The law is written more broadly, covering situations of exploitation that many immigrants silently endure. An employer who underpays you, refuses breaks, or threatens to call immigration if you complain may qualify as an abuser under T visa standards. A partner who demands domestic labor, controls your movements, or uses fear and intimidation can also create circumstances that meet eligibility for a T visa. Even if abuse happened years ago, or the abuser is no longer alive, applicants may still qualify. Time does not erase eligibility in these cases. The T visa is powerful because it can protect you from deportation, allow you to apply for a work permit, and even extend protection to your spouse and children. It can also forgive prior immigration violations, such as unlawful entry, misrepresentation, or false claims to citizenship. Unlike other visas, it does not require leaving the United States. Unlike the U visa, the T visa does not require a signed certification from law enforcement. Reporting is part of the process, but police approval is not mandatory. For many people facing few other choices, this option may be the difference between deportation and a pathway to a green card. Safe green card pathway number 2, VAWA. The second safe pathway is through VAWA, the Violence Against Women Act. Despite its name, it applies equally to men, women, and even parents of U.S. citizens. VAWA protects people harmed emotionally or physically by U.S. citizen or lawful permanent resident relatives. This includes spouses, children, and sometimes even parents. The abuse does not have to be physical. It can be emotional, financial, or psychological. Control, threats of deportation, or withholding immigration support can all qualify as abuse. A spouse who sabotages your immigration case by refusing to attend an interview or withholding documents may be considered abusive under VAWA standards. A child over 21 who threatens to call immigration on a parent can also be considered abusive under the law. Unlike traditional family petitions, VAWA does not require the abuser to sponsor you. Applications are self-filed, completely confidential, and USCIS protects the privacy of the petitioner. The rules for evidence are also more flexible. The legal standard is any credible evidence, which means that even a personal affidavit can be enough for approval. If granted, VAWA can provide work authorization in less than a year and a green card within 3 to 4 years. It can also protect children and grant them status. This program remains fully intact and has not been touched by Trump's policies. It continues to function exactly as it always has. Why these two options still work? T-visas and VAWA petitions remain safe because they are written into U.S. law. They cannot be ended through executive orders or simple policy changes. This makes them some of the most reliable legal protections available today. While other pathways collapse under backlog, restrictions, and political pressure, these two continue operating. They also provide forgiveness for issues that block other petitions. Unlawful entry, misrepresentation, and even past deportation orders may be waived under these programs. For immigrants running out of options, this is critical. These programs still represent real hope and real pathways to permanent residency. Real-life impact. Attorneys across the country continue to file and win T-visa and VAWA cases in 2025. Families who thought they had no chance are now living legally and securely. Some cases have succeeded with minimal documentation, relying mainly on affidavits and personal testimony. Others have overcome previous denials by reframing the case under these protections. There are even examples of immigrants who had lived for decades in fear, finally gaining lawful status through these programs. For them, it meant stability after years of uncertainty. The success stories show that these programs still work, even while other parts of the immigration system become more hostile and unpredictable. What immigrants must understand in 2025. Immigrants need to recognize the shifting reality. Family and marriage green cards are no longer predictable. Asylum is shrinking. U-visas are nearly impossible due to delay. But the T-visa and VAWA remain safe, effective, and confidential. These options continue to provide pathways to work permits, protection from deportation, and eventual green cards. Understanding these programs may be the most important step for anyone living in uncertainty today. Closing. Immigration has become harder. Green card approvals that once seemed secure are now under attack. But two pathways remain safe, untouched, and effective. The T-visa and VAWA are still working as Congress intended. They can protect you, your spouse, and your children, and they can lead you to lawful permanent residency. Even in an environment of rising denials and shrinking opportunities, these programs stand out as lifelines. They remain among the last dependable routes to a future in America. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, and see you in the next video.